Welcome to the Legal View. I'm David Hogg.
And I'm Aaron Gartlan. Tonight we're honored to have Houston County Probate Judge Luke Cooley as our guest.
American law is complex and not always easily understood, so a little help and advice can go a long way. The attorneys of Hogg and Gartlan Law Firm in Dothan present Legal View.
The Legal View with Hogg and Gartlan.
Luke Cooley has been Houston County's probate judge for 16 and a half years, and we're proud to have her on our show tonight to talk about the office of probate judge and the various legal matters that she handles. Tell our viewers a little bit about you personally, your family. I know Wallace Cooley is your husband, and tell our viewers what Mr. Cooley does.
Okay, let's just start with me. I was raised in Savannah, Georgia, and Wallace and I met at Florida State University, and when he finished school, the Vietnam War was in progress, and Wallace had to go into the service, and I just sort of trailed behind him till we finished up, and he ended up in Atlanta. By profession, I was a social worker, so there were always jobs for social workers, and I could move from place to place. When we were in Atlanta, we made a decision to get closer to family, so we ended up in Dothan, Alabama, where he was born and raised.
And Judge, you mentioned being a social worker. You actually work for the Department of Human Resources here in Dothan, I believe. Is that right?
Well, yes, I worked for a department in Florida, in Georgia, and then in Alabama. Then I went back and got my master's degree at the University of Alabama. I got my undergraduate degree at Florida State. I find that it has been a real help. Now, I worked for the Department of Human Resources, but then I moved to the hospital, and I worked for the Southeast Alabama Medical Center for many years as the director of their social services before deciding to run for office. Beside the administrative functions, which everybody, of course, likes to think about the probate office for your driver's licenses and your business licenses, your tags that you wait in line for, all the things that business-wise that the probate department handles, in the actual court function, we do exactly what we say we do, probate wills. Now, the probate of a will is just the opportunity to bring the will of the person who died into the court and have their wishes known to the court in a legal proceeding. And then the court sees that those wishes are carried out. And that's pretty much what the probate of a will is. If you don't die, and if you die and you don't have a will, what do? The state of Alabama and most states have a solution. You do an administration, and so then you do the same things mainly, except that the law actually sets out the legatees or the heirs. The person who died doesn't get to set those out. So that's one of the big things, which is the probate, which is what we're known by, of wills and administrations. One of the fun things that we get to do are adoptions. The state of Alabama now has adult adoptions and children's adoptions. A lot of people don't realize you can still get adopted as an adult. So we do those, and they're a lot of fun, and we make a big production of it. And I think that in the years that I have been there, I have found and seen more problems in our community, and it's a sign of the times with economic problems and the drug problems, that we find more and more relatives, as in grandparents or great-grandparents or aunts and uncles, having to pick up the adoption of these children that they have probably been caring for many years before they come to the adoption stage.
Under what circumstances would an adult be an appropriate candidate to be adopted?
Well, it's usually not for financial means, and the fact I have not done but about 3, because the law's only been in effect for about 2 years. And the ones that I have had, some of them have been adoptions that were done early for them, and then they find like a natural parent and they want to go back and be the child of their natural parent, and they'll be adopted for that reason. Some of them have to do with handicapped adults that have been raised maybe in a foster home or something, and then they get 18, and normally that ends the foster care. But some of these foster parents will step up and say, well, you know, I want to adopt because I have cared for this person for this many years and I want to continue to be their caregiver. So there are lots of different reasons. I've not had anybody that wanted to get adopted for that $1 million yet.
Also, I've noticed that in your minor adoptions, adoption of a child, you have a nice ceremony where you wed the child and the adoptive parents. Is that something that you came up with, or is it something that other probate judges do?
Well, a few have taken my ceremony. I have shared it with other probate judges. But no, I invented that particular ceremony, and I find it most effective. Some probate courts still go the traditional matter of having an actual court procedure and going through witnesses, etc. It's my theory is if I don't have to do that, and sometimes you do have to get testimony, and that changes the perspective of what you're doing. But on the most, we have some really great attorneys here in Houston County, and they do all the paperwork for me, and they get it right, and they get it legal, and I have a wonderful staff who will catch you if you don't. So by the time it gets to me, it's all signed, notarized, sworn statements, and there really is no reason to go back and redo what's already provided to the court. So that gives me that extra time to do my little, as you call it, wedding ceremony, and it was certainly based on a wedding ceremony to, when I call it, unite families.
And it's a very touching ceremony too. And you mentioned having good lawyers here in Houston County. Aaron and I were talking earlier about the role of attorneys in estate planning.
And Judge, I know you mentioned that it helps the process and to, you know, the attorneys filing the adoptions and so forth, but do you find that also in the probate proceedings that it makes the process easier for the public if they have attorneys involved in adoptions and also the administration of an estate?
Certainly it does. In fact, when I talk to senior citizens, I try to help them plan a way out of ever even coming to probate or having their estates ever have to come to probate. And you get there by having a good estate planning attorney to walk you through the process and make those plans and add those names to wills and deeds and bank accounts and things that are beneficiaries if you don't want to do that, so that you do not have to even spend the money to come to probate. Now, there are some estates, of course, that are large. There are some people who do not want to ever let their children have their names on deeds. And they have good reasons, I'm sure, but if they talk to an attorney ahead of time, sometimes you can just skip probate altogether, or if you can't do that, then by the time you get to probate, you will have a good will that's in good standing with no problems, and you don't even have to come to court. Your attorney submits it to me, I follow the procedures, get it admitted, everything's been done, and we move right on through that 6 months waiting period, and within a year, that estate can be finished. Guardians and conservatorships are a big function of the probate office that you can't get in any other court. So when you come to us for your guardians and conservatorships, the guardian is sort of like the parent of the person, is stepping in to become the caregiver and the parent of the ward is what we call them, and it can be either an adult or it can be a minor also. The conservatorship is the money business, and that person takes care of the estate or the monies which that person has coming to them, like Social Security and annuities and all those kinds of things, if they have then declared incompetent and cannot do that on their own. There are limited conservatorships where we allow the ward to do a lot of things, and just maybe some of the major expenses and monies that come in are handled by that conservator. They are big functions in the office because we have to do yearly accountings on them. The person who's the conservator posts a bond, and it's kept up every year so that if that person were to try to walk off with some of the funds, I have an insurance company that's going to come after them. So their monies are protected in a conservatorship. A good judge follows those cases and knows who they are and checks them every year to know where these people are and who's caring for them. A good guardian will make all those decisions that are necessary on medical care, housing, clothing, all the things that a parent would do to see that that person is well cared for. And the conservator is strictly in on the money. Now, can it be the same person? Yes, it can be the same person. But is it sometimes better to separate the functions? It definitely is that too. So that's the decision that's before the court. Who is the best person to take care of the ward? And should it be together or should it be separate? And let's be sure they understand their responsibilities in that function.
And Judge, the types of circumstances that might make it necessary to have a conservatorship and a guardianship for a minor, for example, could be where a minor is inheriting a large sum of money, correct?
Correct. They may be getting some insurance monies. Normally in those circumstances, though, David, you would not have a guardian. A guardian is usually when the parent of a minor, when the parent has come before a court and been declared not able to handle that child, or they walked off and left the child, or the Department of Human Resources has had custody of them, or even the most frequent that we see are mentally handicapped children that, and of all ages.
And in an adult situation, you could have an adult who has gotten injured or sick and is no longer able to make decisions for themselves. Is that?
Correct. And actually the law provides for that to be able to be done even for like alcoholics, drug addicts, which we can't do in mental commitments, but we can help with the guardian and conservatorships. But in the adult, it could be as we grow older, and my gray hair is going to show a bit, but you know, we have to make the decision somewhere in life, if God gives us the ability to live a long life, that we may not be able to do all of the things that we have done in our younger years, and may not be able to manage our monies as well as we have in the past. And in that case, usually family steps up to the bat and will come to the court and say, I think mom or dad or aunt or uncle has a problem and we need to address it.
Now, some planning can be done along those lines too with a durable power of attorney, right?
Yes, a durable power of attorney usually works fairly well. I think the biggest problem that we have with that is when families disagree. Sometimes children do not want the other child to be that, and sometimes they feel like that they need a hearing before somebody that's maybe not so partial and will make that decision, and that moves into the guardianship.
And so then the court needs to step in and really decide who's going to care for grandmom or for mom.
Correct.
Right. Having that durable power of attorney does have some significance in that decision, doesn't it?
Correct. The law says that that is the first person that the judge should look at, is the person who has been given that power of attorney.
But again, when you're sitting reviewing that, you're looking at, as the probate judge, you're looking out for that person's best interest. Essentially, right. Isn't that?
Right. And I'll tell you, one of the things that frequently comes up is mom might have lived up north with a daughter for a long time and has given that daughter power of attorney, but for some reason mom has now moved to Houston County and she's doesn't have that power of attorney except with a child that's up north. And that's a little inhibiting to have to try to take care of mom in Houston County and you're up in New York or somewhere. So it's sort of a policy of mine, and this is not law, is that I'm going to look at whichever relative lives in the county that's going to where the person's going to be, that they will be taken care of, because they need to get to them. They need to get them to the doctor and the hospital, and they need to see they got groceries, and they need to see their rent's paid. And if they're going to do that, then they need to be the guardian.
Sure. Well, Judge, what are some other responsibilities and services?
I guess the other key one, there's some other minor responsibilities, is mental health. And that's a particular topic that I care a lot about. We have mentally ill in this county, as in all counties, and they need care, and they need help, and they need to maintain their medications, and they don't always think they have to do all those things. And sometimes they, if you were an alcoholic, I'd say fall off the wagon. But if you are a mentally ill person, it's just a matter of judgment. And they become either violent, they can become so depressed that they can't function. They can be paranoid, scared of people. We even move over into the dementias that are a mental illness. So these people, when they need help and need to go to the hospital and they refuse to go to the hospital or refuse to take their medications, that's when the court intervenes.
And what's the procedure for handling that?
Someone places a petition before the court, or they come in and talk with my mental health liaison from Spectral Care, and she'll help them go file a petition, get them to an attorney to file a petition. And that's actually the paper that brings the person before the court. That's a petition that says, we have a problem, court, please look at it. And once the petition is filed, then the person goes usually to the hospital, sometimes privately to a doctor, and that doctor or a psychiatrist determines whether or not that person actually has the mental illness according to the law. And once they determine that they have a mental illness, then the court steps in and says, okay, doctor has said this is true, the court agrees. The court doesn't have to agree, but the court usually will try to at least listen to that doc. Listen to the family, saying what the behaviors have been that have caused this person not to be able to stay in their own home. And if it deems it, the court then has some choices. The number one choice, of course, is to send them to the state hospital. And that is a mental institution. It is an acute care institution. It is not a long-term institution. You don't send them there to be there forever. It's short-term to get treatment. The second is an outpatient commitment, which just says, okay, we're going to make a plan with our mental health center or with your private physician, and you're going to have to take your medications and you're going to have to go to your appointments, and I don't make the treatment plan, the doctor makes the treatment plan. And if you don't do that, then you're liable to be back before this court again, because you would be in contempt of the court order. The third thing they can do is dismiss it. Dismissals mostly will occur when it's dementia and the hospital has found a nursing home bed that the person can go to for care. And then the court cannot order somebody to a nursing home. So we will dismiss the case, and then hopefully a guardian and conservatorship will be in place to help them make that placement.
And the court makes a decision if they find that the person has a mental illness and make appropriate orders based on a finding that the least restrictive condition is placed on that person. Is that right?
That's right.
And tell the viewers about that, basically what that means.
Well, least restrictive is where can this person go and receive the care that they need? Are they responsible enough to participate in that care? Or if they are not, do they have to go to the state hospital where they have no choice?
Well, Judge, election time has to be a fun time around the probate judge's office. Tell us about your handling of elections. What all does the probate court do when it's election time?
Well, the probate judge is the chief election official for the county. And that means that they run the elections. We work with the circuit clerk, who's a member of the board, and the sheriff. And we choose the poll workers according to some information that we have on, usually we do long-term poll workers, but the parties, Democratic and Republican parties, give us a list of the people they think would make good poll workers. We select poll workers. You have to be able to vote and live in the precinct where you're going to vote, where you're going to work. And we conduct poll school. We have to see that all the precincts are available to be used, that they are have electricity, etc., going to them. Check the actual physicals parts of the facilities. We have to see that the people who are registered to vote with the registrars are on a poll list, so that when you get to the polling place, your name will be on the list. We do a poll school, and generally we do all the qualifications for local county officials. Now, we do not qualify state or federal officials, just the local officials. And we work with the Secretary of State in the election process.
We talked a little earlier about the probate process, and there's a procedure when someone dies without a will that you mentioned concerning administering the estate. Do you see instances where someone dies because of, let's say, an accident, and there's an estate that gets opened, and there's going to be a wrongful death lawsuit brought by the person who's appointed to handle the estate?
Correct. And when that happens, you still have to go through a regular court procedure. You don't necessarily have to come to court, but you have to use your attorney, and you have to come through the court, because you can't sue for the estate to have monies from a wrongful death unless you have an estate. And the only way to have that is to come to court and file an administration. I guess my biggest problem with those is they do run a long time. You know, the circuit court sometimes could be a little slow. No dispersion on my circuit judges, but it's just a little faster when you handle wills and probate than having to do an administration. But when they get down the process, we still have to do the things for an administration of a small wrongful death that we do if you died with $1 million and didn't have a will. You know, you still have to do an inventory and administrations of those estates. So although it's small, you still have to do them. There are some other options. I don't know how far you want to go, David, but like small estates. You know, if you die and you leave a small estate, less than $25,000 now, thank you, Alabama legislature, you can get your lawyer to file for a small estate, and it is a lot less money, a lot less time, and it's an easier procedure to go through. But that's just a different kind of estate that we are now handling a lot of.
And Judge, when you talk about the personal representative, that basically, the person that's appointed by the court and gets the letters of administration,
Correct.
They have the authority to act on behalf of the estate in the best interest of the estate, which would include handling affairs of any type of litigation, again, whether it was a wrongful death case or any other type matters that the estate would need to carry out.
Exactly. There are a lot of things that occur when you're trying to get an estate settled, even, you know, wrongful death, but there can be other types of suits that the estate needed to bring and may not have gotten around to it, or there's just a lot of other issues that come up in getting monies from an insurance company.
Sure.
You know, all those types of things that the personal representative does.
Or the person or the deceased may have been involved in a lawsuit or some type of litigation, and the estate would need to carry that out on behalf of that person. So it just basically gives that person the legal authority to act on behalf of the estate, right?
Correct. And it does do things like close businesses. Person was in a business, maybe they were going to close it, maybe they weren't going to close it, but now you have to close the business. And there are a lot of legal entities that you have to go through to close down a business, and that person can do that. They essentially act as the deceased would if they were alive and could.
And Judge, while the estate is open in that administration process, or guardianship or conservatorship, or the commitment type mental health proceedings that you talked about earlier, as the probate judge, while those cases are open, you're more or less in a capacity of overseeing everything to make sure that it's being handled properly. Is it?
That is my
right?
role. That is my role. On the whole, I would say that the personal representative gets instructions when they're there. They have an attorney they can turn to. And so they have some ideas about what they need to do. But if they don't turn in their reports on time, then the probate court's coming after them, so we can keep up with what's going on. And I know my constituents out there wonder about those letters that they get saying you're gonna come to court if you don't turn in this report or that report. But essentially that's the only way that the probate court can supervise what's going on. Other than that, we're spending your money by calling your attorney and making them act rather than you acting on your own. So if you can help us out, we're real good about sending out reminders, and they're real nice, the first couple of them. The third one usually is going to say you are now being subpoenaed before the court because you didn't do what you needed to do. So don't ignore letters from the probate judge. I'm a nice person. I send out nice letters.
Get those reports in if
Get
you
those
are
reports in and let me help you get it done.
Now, your office also handles certain matters related to property, real property, I think, condemnations, is that right?
Yes, that's true. When the county or the state or somebody needs a right-of-way somewhere, then they will issue something called a condemnation, and it's a way of getting you to exit a piece of your property for somebody else's benefit. And there's a lot of controversy about that, but basically, I just have to tell the viewers, most probate judges are like me. We don't want to give up 1 inch of our property. We don't want you to give up 1 inch of your property, and you don't want to. But sometimes there's a public road going in, there's a utility going in, it's a public works condemnation, or the only other thing that I really think you have a hard time understanding is when your neighbor is landlocked and they have to get away to get into the property, to farm it, to build a house, to do whatever they're going to do with that piece of property.
In other words, there's no way for them to get to their property without going across somebody else's property. And so what happens is that then when it's brought to the court, and please be assured when I say it's brought to the court, I'm talking about my court. You know, different judges going to handle things a little differently. But we look at the whole piece of property and everybody that surrounds, and the law is very specific about where you go to look for that egress and ingress, the ins and outs to that property. The law tells you, the judge, where to look, and that's what we do. We go and we look. And so just because somebody is putting a condemnation on your property does not mean that's necessarily going to happen, or that's going to happen where they think it's going to happen. Judge, it's been great having you on our show. It's been very informative, and thank you for coming.
I appreciate you having me.
Thanks for watching The Legal View.
To submit legal questions you may have, email to aaron@hoggartlanlawfirm.com. Thanks for watching. This has been a production of the Hogg & Gartlan Law Firm and WDFX-TV, Fox 34.
The Legal View with Hogg and Gartlan.